was not there. On the weekend of July 14th and 15th, my client took his daughter out to Colgan's campground. He'd done some research on osteogenesis imperfecta, the disease that his daughter suffered from, and knew that she needed exercise. Her dance classes had been successful, so he figured some hiking might be okay. The trip started out fine. They went and purchased camping supplies, and despite the fact that Mr. Ryder thought his daughter didn't need it, he bought her a hiking stick. They began their hike, but Parker got too tired. So Mr. Ryder allowed her to sit down. And yes, they did bicker a bit, but Mr. Ryder took his daughter back to the campground and allowed her to take a nap while he prepared dinner. Members of the jury, sometime while Mr. Ryder was preparing dinner, Parker disappeared. And he doesn't know what happened to her. Now, you may be angry about the way that Mr. Ryder conducted his parenting. You may wish that he had kept a closer eye on Parker Page. But members of the jury, this is not the question in today's trial. The question that the state needed to answer for you was whether or not Mr. Ryder murdered Parker Page. And they were called to prove that my client knowingly engaged in actions that killed his daughter. They were called to do this by the standard beyond a reasonable doubt. Now, this is the highest bar in our legal system, and for a good reason. This means that if any aspect of the state's story you find reasonable doubt in, even if it's just one aspect of this story, you must find my client innocent of aggravated murder. And members of the jury, you heard throughout today's trial a lot of reasonable doubt. So let's walk through that today. The first area of reasonable doubt is in Midland's Police Department's investigation. Now, Counselor Graham relied on a couple aspects of this investigation in his closing. The first being a life insurance policy. However, members of the jury, I ask you to find out which part of the state's story this correlates into. Was it a part of the investigation of Mr. Ryder? Do they know that my client needed this money or somehow had any motive with this money? Well, Midland's Police Department wasn't required to find a motive. In fact, they were required to find an action or some reason for Parker Page's death. However, in this aspect of the investigation, they failed. You heard that their first hiker that they spoke to was Mr. Kelly Dews. Mr. Kelly Dews led them to the exact location of Parker Page's body. Yet, Detective Chesney and Midland's Police Department never considered him a suspect or interrogated him. You also heard that there was another camper on the campground that day, Mr. Lee, who fled the country after July 14th. He wasn't in the country on July 15th for Detective Chesney to speak to. And when he got back, he was just asked to prepare a statement. He was never considered a suspect. Lastly, Remy Mouchard had possession of one of Parker Page's personal items a week after the incident, after an Amber Alert had been released, after this had been all over the news. And instead of interrogating Remy Mouchard, Detective Chesney thanked him for the phone and never considered him a suspect. Members of the jury, if you think that somebody else should have been considered in this case, if you think that there should have been more interrogations and more delving into this evidence, that is reasonable doubt. The second aspect of reasonable doubt here is whether or not a push or shove even occurred. Members of the jury, ask yourself if you have an eyewitness that places my client's hands on their daughter. Or even that hiking stick. Mr. Dews could not tell you that that hiking stick ever made contact with Parker Page. Mr. Dews testified to an altercation, but an altercation that happened significantly before the state's claimed time of death. A push or shove needed to happen for the state's case to be reasonable between 4 and 6. There is no eyewitness that sees Jordan Ryder anywhere near the scene of this crime between 4 and 6, or places my client's hands on their daughter between 4 and 6. And there is reason to doubt that a push or any type of blunt force caused this. Now, Counselor Graham pushed back against my expert, but my expert told you that he has years and years of experience in this field. There is legitimacy to the science that he put behind this. He told you that osteogenesis imperfecta creates a lot of bruising, and that these bruises can be justified by multiple objects on this campsite. A branch, a rock. You cannot be certain that any of the bruises on Parker's body were sustained by what Dr. Quincy tells you they were. And with no evidence of a push or a shove between the hours of 4 and 6, that is reasonable doubt. And lastly, members of the jury, let's talk about my client's location between the times of 4 and 6. We have 2 witnesses, Armani Rodriguez and Jordan Ryder, who tell you that Jordan Ryder was over by the campsites, all the way over by the head of the trail, almost a 2.5-mile hike that could take hours away from Calkins Rock Overlook, between the hours of 4 and 6. The state tried to have Kelly Dews tell you that they were over here. But at the end of his cross-examination, Mr. Dews couldn't place Jordan Ryder there. So, members of the jury, the only reasonable explanation is to know that my 2 witnesses are telling you the reality. Jordan Ryder was not there. In fact, during the time of Parker Page's death, Jordan Ryder was 2.5 miles away. Now, members of the jury, with all of this reasonable doubt in the state's case, it becomes almost impossible to place Jordan Ryder in any relation to this crime. And it's unfortunate that this is the story that the state chose to pursue, because we can't bring justice to a 12-year-old girl's death. We can't bring justice to Mr. Ryder's loss of his beloved 12-year-old girl. But members of the jury, with this much reasonable doubt, the state did not meet their burden. And therefore, you must find Jordan Ryder innocent of aggravated murder, because he was not there. Thank you.
Rebuttal?
Yes, Your Honor, before I proceed, may I inquire as to how much time I have?
1 minute, 29 seconds.
Can I proceed?
Please.
Your Honor, exactly what I told you that the defense has been trying to do throughout the entirety of today's trial, but just toss out things hoping that they'll stick. That's exactly what they did just a couple moments ago, when they wanted to leave a lasting impression. Rather than focus on the person that was seen fighting with Parker right above where her body was found, and rather than focus on the person that submitted an insurance policy that would give them $200,000 if Parker died, rather than seeing that person that had every motive, they want you to focus on completely different people. They said focus on someone that had no reason to hurt Parker. And let's say that they went and took Parker up to that exact same spot where she was seen with Mr. Ryder and then pushed her off. Members of the jury, that's not reasonable. That's not reasonable doubt. You see, opposing counsel, they said that Jordan Ryder wasn't even there, but there's an eyewitness that places them there. And they didn't give you any reason why you shouldn't believe Mr. Dews. The things that weren't with Parker Page's body was that she didn't have her hiking staff. If Mr. Ryder says he fought Parker over this hiking staff because she wanted it that badly, why would she leave without it? It was found in Mr. Ryder's tent, right next to him. Members of the jury, the evidence is clear. Find Mr. Ryder guilty of aggravated murder. Thank you.
Thank you.
Do you know what your comments?
Oh, no.
Okay.
Sure. My name's Rex Gradeless. I did 4 years when I was in college, and I've been coaching for 6, and I've been an attorney for 10. Licensed in 2 states. Former assistant attorney general in the state of Illinois, and now I work for the Illinois EPA. And my last trial was last week. So that, for whatever that may be worth, my comments are included, obviously, in the sheets. So I've seen way too many mock trial rounds in my lifetime. So the traditional thing is a couple of general comments. I don't have much. One of the top rounds I've seen all tournament. So you guys are in a great position for regionals. Good luck in regionals. Go out and get your points. Go out and get your points. You should be in a good position, I think. I have like 3 things. Dates on the demos. I don't know if it matters. Maybe it will. Maybe you run into some team that has a problem with that. I don't know. Just I've been advising some teams to be safe with that. Theme with the prosecution, the push too far. I didn't see that as much with the evidence. I don't know that it affected the scores any, because there's really no spot in the sheet for that. But so I don't know if that's something to consider. Maybe their witness call kind of, threw you off your planting. I don't know. Lopez did. I don't know if we talked about how much Lopez was paid in this for any kind of bias. I don't know if that's a reason for that. My last expert witness was paid $3,500 a page. So when you subtracted it, so I think Lopez's report's like 5 pages. So you can divide that 60 grand, whatever, 40 grand by 5 pages. Be an interesting fun fact for some bias there for Dr. Lopez. And then I think we didn't talk about any forensic evidence in the stick. I don't know, maybe a timing issue. Nope, might be general comments.
I don't have as much experience as my co-judge here, but I am also a trial attorney. I also tried a case this week, so I hope that the feedback I was able to write here is useful to you. I would echo that this was certainly the best round I saw this weekend, and you should definitely walk away from this proudly. There are several of you that are absolutely ready to start trying cases. So go to law school and become trial attorneys. So I think both sides had a pretty coherent theme and theory from my perspective. There was a couple things that I said I was going to talk about at the end. This intrinsic versus extrinsic thing. Intrinsic evidence is when you directly question a witness about a particular event. So getting up and talking to Lopez about, isn't it true that you lied on this particular occasion? That would be an intrinsic impeachment by a specific instance of conduct. It's directly questioning the witness about it. Extrinsic impeachment is where you use a document or you have some other witness come in and talk about, well, that person's a liar because on this particular occasion they lied. So Rule 608B allows, I think on cross it allows both, intrinsic and extrinsic, pursuant to a ruling by the judge. But on direct examination, you can't support it with extrinsic evidence. You can only, if it's been attacked, you can come back later, but I think that was the mix-up a little bit. I think expert foundation is, I mean, it's hard, right? It's kind of a weird rule. Doesn't give a lot of guidance about how to qualify an expert. I think both sides were pretty conclusory in the foundation that you exhibited or elicited. You ask questions like, did you use a reliable method? And what you're doing in that situation is asking the expert to decide something that is up for the court to decide. It's up for the court to decide whether the method was reliable. So the question is, what is your method? And then tell us about that method. Why do you use that method? Is that method relied upon by others in your field? That kind of thing. How did you apply that method to this case? Not did you reliably apply it? It might seem like I'm splitting hairs here, but it's really for the judge to decide whether the witness is qualified, not for the witness to make those conclusions himself or herself.
Yeah, that's Tara Reader v. Dow, and then the case right above that.
Davis v. Adams.
Adams, yeah. So, for what it's worth.
Um,
Fun facts.
Yeah, I think that was most of it for me. This was, like I said, outstanding. I will say, okay, all right. So I'm one of those prosecutors that on my closing argument, I spend about a quarter of my total time. I mean, I'm not timed, but overall, the amount of time that I'm up there, I spend about a quarter of my total time on the actual first part of the closing argument. Right? I say, these were the elements, this is the evidence that I presented that proved the elements, and then I sit down. And then I let the defense say whatever defense lawyers say, and then I get up and I spend roughly 3/4 of the time that triple the time that I spent on my opening part of my closing, talking about why the jury shouldn't believe anything that they just said and why they should believe all of my evidence over their evidence. And you kind of do that in the first part of your closing, Mr. Green. And it's effective, but I think if you saved more time for rebuttal and explained exactly what a reasonable doubt is and why everything that they said was not reasonable, you could do that all in one sweep and ultimately save time on your closing instead of addressing it twice. So I think you should save maybe 3 or 4 minutes of your closing for rebuttal. to give you, because they don't have an opportunity to respond. That's the biggest thing.
You only had a minute to.
Yeah, you get last word. That's super powerful. If the last word the jury hears is everything that they said is ridiculous and unbelievable, then yeah, you should capitalize on that. That's very rhetorically impactful. So okay, I won't keep you any longer. Have a good
Safe trip.
rest of your season and good luck at regionals.
Good job. Good job.
Yep.
Give me 1 second here.
Good job.
Nice job, good job.
Thank you so much for your time.
Excellent job.
Thank you.
Good job.
I need to know.